police military units to the town of Varesh. In response, the 3rd Corps Command issued a combat report stating that it had issued orders that brigades use military force to prevent chaos and the destruction of property in Varesh. The trial chamber found that the 7th Brigade neither received the 4th November 1993 Operational Group ICTY combat report to the 3rd Corps Command, nor the 3rd Corps Command report in response. Yet, from the content of the 3rd Corps Command report, it inferred that the 7th Brigade must have received orders to use military police forces to prevent chaos and the destruction of property in Varesh, given that the 7th Brigade was subordinated to the 3rd Corps Command and present in Varesh. The 3rd Corps Command combat report, however, failed to make explicit the identity of the perpetrators of the acts of wanton destruction in Varesh. The Appeal Chamber notes that other brigades were also present in Varesh on 4 November 1993. The trial chamber also found that the operational group ICTY issued a separate order on 4 November specifically directed to the 7th Brigade commander, which explicitly refers to activities of plunder and the need to prevent them, but does not mention acts of destruction. The Appeal Chamber concurs with the trial chamber that given the evidence taken as a whole, the inference that the 7th Brigade must have received order from the 3rd Corps Command on 4 November does not establish by itself Kubura's knowledge of his subordinates' acts of wanton destruction. Second, the Appeal Chamber considers that Kubura's knowledge of the acts of wanton destruction cannot automatically be inferred from his awareness of the plunder in Varesh on 4 November 1993. Indeed, the trial chamber's finding regarding Kubura's knowledge of the plunder in Varesh on 4 November rests on a much broader evidentiary basis. Furthermore, the trial chamber relied on Kubura's knowledge of and failure to punish his subordinates' past acts of plunder. The trial chamber made no such findings with respect to any past acts of wanton destruction by Kubura's subordinates. Thus, while there was a sufficient evidentiary basis for the trial chamber to conclude that Kubura had knowledge of the acts of plunder in Varesh, it was reasonable for it to conclude that his knowledge as regards the acts of wanton destruction was not established beyond reasonable doubt. In light of the foregoing, the Appeal Chamber finds that the prosecution failed to establish that no reasonable trier of fact could have concluded on the basis of all the admitted evidence that Kubura's knowledge of wanton destruction in Varesh on 4 November 1993 was not established beyond reasonable doubt. Kubura's acquittal is confirmed. Finally, I turn to the appeals concerning the sentences rendered. Hadžihasanović did not specifically appeal his sentence, but alleged that the trial chamber erred in that the disposition of the trial judgment does not adequately reflect some of the findings made by the trial chamber in the body of the trial judgment. Kubura's appealed his sentence as manifestly excessive, and the prosecution appealed both Hadžihasanović and Kubura's sentences as manifestly inadequate. The appeal chamber allows Hadžihasanović's arguments and corrects the disposition of the trial judgment concerning the temporal scope of the cruel treatment at the Zenica Music School to render it consistent with the trial chamber's finding. As regards the impact of this shorter period of responsibility on Hadžihasanović's sentence, the appeal chamber first recalls that the trial chamber, in its sentencing determination, correctly determined that the cruel treatment at the Zenica Music School took place over approximately 7 months and not 9 months, as erroneously indicated in the disposition of the trial chamber. The appeal chamber further notes that the trial chamber's finding regarding the large number of victims involved in the detention facility in Zenica, which was considered an aggravating circumstance, remains valid for the relevant period. Thus, these factors remain unaffected by the above correction to the disposition of the trial judgment, and there is no impact on the sentence. For the reasons set out in the judgment, the appeal chamber dismisses the prosecution's and Kubura's argument. The appeal chamber finds that the trial chamber properly considered the gravity of the crimes, the relevant aggravating and mitigating factors, and the sentencing practices in the former Yugoslavia. I will now read out in full the operative paragraphs of the appeals chamber's judgment. That is the disposition. Mr. Hadžihasanović and Mr. Kubura, will you please stand? Here is the disposition. For the foregoing reasons, the appeal chamber, pursuant to Article 25 of the statute and Rules 117, 118 of the rules, noting the respective written submissions of the parties and the arguments they presented at the hearings of 4 and 5 December 2007, sitting in open session unanimously, allows Hadžihasanović's appeal in part with respect to ground 3, reverses his conviction for failing to take the necessary and reasonable measures to punish those responsible for the murder of Mladen Havranak, count 3 of the indictment, and the cruel treatment of 6 prisoners at the Slavonia Furniture Salon on 5 August 93, count 4 on the indictment, as well as his conviction for failing to take the necessary and reasonable measures to prevent or punish the cruel treatment at the Gimnasia School building, the Slavonia Furniture Salon, the Iskra FC Stadium, and the Vojin Palexic Elementary School in Bugojno as of 18 August 93, count 4 of the indictment. Allows Hadžihasanović's appeal in part with respect to ground 4, concerning certain errors in the disposition of the trial judgment with regard to his conviction entered under count 4 of the indictment for his failure to prevent or punish the cruel treatment at the Zenica Music School. Sets aside the related portion of the disposition of the trial judgment and replaces it with the following. Count 4. Guilty of failure to prevent or punish cruel treatment at the Zenica Music School from 8 May 93 to 20 August 93 or 20 September 93, in addition to failure to punish cruel treatment at the Zenica Music School from 26 January 93 to 8 May 93. Allows Hadžihasanović's appeal in part with respect to ground 5, reverses his conviction for failing to take the necessary and reasonable measures to prevent the murder of Dragan Popović on 21st October 93, count 3 of the indictment, and his conviction for failing to take the necessary and reasonable measures to prevent cruel treatment at the Orajak camp from 15 October 93 to 31st October 93, count 4 of the indictment. Reduces the sentence of 5 years of imprisonment imposed on Hadžihasanović by the trial chamber to a sentence of 3 years and 6 months of imprisonment, subject to credit being given under Rule 101C of the rules for the period Hadžihasanović has already spent in detention, and dismisses Hadžihasanović's appeal in all other respects. Allows Kubura's appeal in part with respect to ground 2, reverses his conviction for failing to take the necessary and reasonable measures to prevent though not to punish, plunder in Varesh on 4 November 93, count 6 of the indictment. Reduces the sentence of 30 months of imprisonment imposed on Kubura by the trial chamber to a sentence of 2 years of imprisonment, and dismisses Kubura's appeal in all other respects. Dismisses the prosecution's appeal in its entirety. Order that this judgment shall be enforced immediately pursuant to Rule 118 of the rules. Mr. Hadžihasanović and Mr. Kubura, you may be seated. I now request the registrar to please deliver copies of the judgment to the parties in this case. Thank you, Madam Registrar. The appeal chamber will now rise.
All rise, voy a volver.